Okay. So today we're going to be starting a new topic, and today's new topic is sales. And I'm very vocal about this. Chapter 19 is my least favorite chapter of this entire semester. So I will, go over some of the things that are necessary, but it's not my favorite, and I don't usually test on it because I hate it. So I don't I try to emphasize the things that are most useful for you that I think you'll benefit the most out of. And if it's not something that I feel that way, I rather spend more time on the things that will be. You'll see that when we talk about like contracts, I love contracts, criminal law, and all that other good stuff. And when we go actually towards the end of the semester, when we talk about corporations and sole proprietorship and businesses and bylaws and all that stuff, that's stuff that I think is very helpful, especially if you're a young entrepreneur and you're thinking about having your own business, or if you're involved in a family business, which I tend to see many students are involved in that type of thing. Then that's going to benefit you a lot more, and so we'll spend more time on that. But with the stuff in sales, it is what it is. So, with that being said, today we're going to go over chapter 19 and 20, not particularly long chapters, but they talk about sales. So, when we talk about sales, the law that actually governs this, it's usually Article 2 and 2A of the UCC, which you probably heard me talk about before. And that's okay. It's the Uniform Commercial Code. It's some body of law that kind of tries and codifies what standards exist when it comes to sales and leases. When we talk about sales and leases and Article 2 and Article 2A, we're talking about certain things. When we use the word goods, goods means what? It means it is a tangible piece of property, tangible piece of property that is movable. So when we're talking about the sale of goods, we're talking about that pen, that notepad, that phone, something tangible that you can hold onto, and it's property that can be moved. And when you sell it, and when there's that sale aspect of it, you're giving it that piece of property is moving from one owner to the other, right? You order something from Amazon, right? Amazon has it. You pay for it, you get it. They're going to now transfer that ownership item from them to you. When I use the word sale, sale is the transfer of goods from one person to the other. So if I own a particular good and I sell it to you, there's a sale between us. You get the item and I get the goods. This is built upon the idea of contracts, right? So you should be seeing kind of like baby steps moving up. We talked about contracts and the relationship between two entities. We're talking now specifically about the sale of those items. What's the difference between sale and lease? This is again common sense. You've heard these terms before. When we talk about a lease, it's not an absolute transfer of ownership from one person to the other. It's actually the transfer of possession of one item to another. The best way to think about it, the most common thing, is a car. You've heard the term, if you leased a car. So when you lease a car, do you own it? Is it yours forever? No, right? You're using that car, you're paying for the use of that car for an allotted period of time, and then you give it back. The ownership is not retained in you, it's with the original owner. So you're just using it for a particular period of time. And in return for using it, you are giving some kind of consideration. You're given money, usually, is what happens. So those are the words that I'll probably be using for the next, duration of this lecture. So that's goods, sales, lease. Those are the items that you might want to know. And those are really the fundamental principles that governs like 2 and 2A. It's just that sale, that lease, what happens with that, who's the owner, who's not the owner, and things of that sort. When we also talk about the sale of items, the sale of goods, there's a concept that you'll hear a lot, and that's actually the concept of good faith. Good faith is something I believe I've touched upon this before, but what good faith is it's a when two parties are entering into a particular agreement so they can each get something out of it. Again, we talked about this in contracts. They're not trying to screw each other, they're trying to mutually benefit from that relationship. So, good faith is when two parties enter into a relationship with one another so they can achieve certain goals. They want to deal fairly with one another. Neither side is trying to screw the other, they're just both trying to get what it is that they want to achieve, that ultimate goal. And when I talk about Article 2 and 2A, it was really just a way to try to put these principles like good faith, like unconscionability and conscionability. I'm going to talk about that in a second, and talk about goods and talk about leases. That way, people have a frame of reference as to what could fall under the UCC, the 2 and 2A. It was trying to codify this body of case law that was all over the place. That way, people have a reference. So, if there's a dispute between merchants over the sale of goods, all right, well, let's look up this section of the law and see what it says. And when you do that, then you can determine whether or not somebody's at fault. You can determine whether or not is the item itself, is there a problem with the item itself, or was it the service aspect of it that's a problem? And so you look at a couple of different things in order to determine what's important, what's not. And I'm going to give you an example. And again, this is all just listening stuff. You don't have to write anything down yet. But when you order, let's say you're getting construction work done at your house, and I think I've given you this example before, but especially for this type of lecture, this is actually a really good example. You order, you want to redo your bathroom, and you order tiles from a tile place. You went to the store, you saw these tiles, they were beautiful. They have this pattern on them, and you hire somebody to install the tiles. After the tiles were installed, you notice that the pattern does not line up. So, is the problem with the item itself? Is it the goods? Or is it with the installation? And so you look at Article 2, that body of law, that guidance, to see which section really applies. Well, the courts have said, well, you look at the predominant factor. What's the predominant factor here in determining whether or not we should be looking at the tiles and then applying this particular section of the law? Or was it the service and installation that was the problem? And then you look at another section of the law. So it was really just a way to give users a potential roadmap of how to sue or what the causes of action were. So we kind of talked a little bit about good faith. Unconscionability. Unconscionability is also one of those legal principles that says, sometimes you have contracts, and although the parties are free to contract in whichever way they want to with one another, sometimes the terms of the contract are so egregious, they're so one-sided, that the court may decline to enforce those terms of the contract because it wouldn't be fair. And the best example I could give you of that is if you have a conglomerate, this big company, that a big real estate company, and they're dealing with this little mom and pop shop, little those little stands at the bottom of those buildings in the city, and they sell like candy bars and soda, maybe a little bit of coffee. And let's say that this person wanted to renew their lease, and the owner maybe didn't speak English very well, they didn't have an attorney, they were pressured to sign it, and this real estate company gave them this contract. They signed it, but then when there was a problem and the real estate company was trying to enforce it, the court says these terms are so bad, nobody in their right mind would have really signed it. Now, this person, we're not saying they're under any intellectual developmental disability, so it's not like it was a void contract because of that aspect, but it's unconscionable. The terms are so unfair, so one-sided, that it would be unfair to have those terms enforced, because you'd be really screwing one side. Both parties did not enter into good faith with one another when they signed this contract. So that's unconscionability. When we talk about when we talk about procedural unconscionability, we also talk about it's how the process was then made. Was perhaps in the contract itself. Forget even the terms. Maybe they use like really tiny print on the bottom. And so procedurally, like it was so small that people couldn't actually see it, or the person that was signing off didn't actually see it. So procedural unconscionability is the process in which the unconscionable action was made. That fine print, that tiny footnote that you need a magnifying glass in order to see. So that's that. And when we talk about substantive unconscionability, that's the actual terms, like, hey, you're going to be paying $1,000 a month for the first year, and then after that you're going to be paying $10,000 a month in rent for 3 years after. Perhaps that's substantive unconscionability, the actual contractual terms in big bold letters. You know what, that's not fair. It's just not right between the two parties. So those are some of the other things that this chapter tells you. When we talk about, like that example I just gave you with the real estate, it was like that big conglomerate with a tiny little owner, like a little mom and pop shop. The courts treat that differently than when we have examples of contractual bargaining between merchants. And why is that? Merchants are held to a higher standards. Why? Because merchants deal with businesses on a regular basis. They're held to a higher standard in court. A business person is presumed to know enough to at least hire an attorney. If they're dealing with a particular good on a regular basis and they have multiple businesses and they have all these other assets, it is presumed that they would know how to enter into a contract properly. It would be presumed that they would have a particular knowledge or skill that allowed them to sign off that document. When you're dealing with a big conglomerate and a person, an individual person, the law, not the law, the relationship is treated differently because maybe that person was taken advantage of. And again, ultimately, we want people to enter into contracts willingly because they want to benefit one another. We're not trying to have people screw one another. So again, when you have a deal between merchants, it's held to a higher standard in court. The code is flexible, the UCC code, and again, you give people the freedom to contract as long as they knew what they were getting into. And that's why when you have a trial, when you have a hearing, evidence comes out. Maybe that small mom and pop shop owner knew exactly what was going on. He understood it, he recited it. Now he's playing like, oh, I didn't know this. And so that's why you have to have a hearing, you have to have witnesses, you kind of have to read people and give the jurors an opportunity to hear and determine for themselves whether or not one party was taken advantage of or if they knew exactly what was going on. So that is also that. Let me see. I'm just going back and forth. I want to make sure that I hit all the stuff on the syllabus. We don't have information sales. Okay. Um, okay. And on your syllabuses, we talk about the formation of sales, mutual assent, open price. Um, So open price is a concept where it kind of goes against a lot of the things I told you before, and I'll give you the reason for that is. So when we talk about a sale of a particular item, we talk about, hey, listen, remember we talked about when there's a contract, it has to be finite, it's got to be exact. The UCC relaxes that a little bit because it says that even when you enter into a contract with another entity, some of those terms can actually be filled later. They don't need to be filled right at that point of contract. And you can have like an open price and it's not going to negate the contract. And the reason that that's said is because sometimes, again, when merchants are dealing with one another, the parties are open to negotiation with certain things. And I'll give you an example of that. If you are a fisherman and you catch fish and you supply those fish to a warehouse that has this fish. You don't know how much you're going to catch. And so if you are only able to catch a little bit because of the season or whatnot, perhaps you're going to value that fish product at a higher price than if you were to have a ton of fish. Because when you catch a lot, you can reduce the price because you want to get rid of your inventory. But if you don't have that much, there's a shortage of, I don't know, salmon or something, you want to increase that price in order to supply and demand. So sometimes when you're entering into a contract, again, usually with merchants, you may leave an open term available because the price will be set at a later time and then it can be negotiated that way. So even if there's no price set at that particular point, you can determine that either at the point of delivery or prior to that date, and the contract will still be valid as long as, again, it's fair, it's entered into in good faith. Because keep in mind, when you have these types of relationships, sometimes businesses are built on those relationships. So if you're that fisherman and you're catching all this fish, and this is a warehouse, or like, whoever takes the fish from you, and then a wholesaler, and then gives it to the stores that have the fish. This is a business that you've been dealing with for a long time, right? Or maybe you want to deal with them in the future. So you're not going to want to screw them, right? Because if you do, that relationship is going to end, and then you're not going to have a business partner. So if you don't have somebody to take the fish from you, what are you going to do with all the fish? You're going to have to find somebody else to sell it to, right? So again, think back to that concept of good faith and wanting to deal with one another and wanting to build on those relationships. So that's kind of the open price. Um, Let me see here. What else do I want to tell you about this? Variant auctions. Okay, auctions. I believe we spoke about auctions before, but uh, we'll talk about that again. Um, Actually, hold on. Let me go back. Let me just look at the syllabus real quick. Oh, manner of acceptance. Let me do manner of acceptance. That's important. Variant acceptance, don't worry, but manner of acceptance and auctions. So when we talk about a manner of acceptance, so how do you accept an item, right? You accept it as long as it's made in a reasonable fashion. And you accept it if you get a receipt. Sometimes you don't need a receipt, right? But most business transactions, there's some kind of receipt, some kind of record to show that it was received by the other party. And you can have the transfer of the sale of goods. It could actually change depending on what the parties agree with and whatever is more convenient for them. So typically businesses are operating 9 to 5, right? Let's go to that fish example. Perhaps the fishermen are going and fishing these fish, catching them from the ocean at like 3 o'clock in the morning, and they need to be fresh. So maybe you need to, once you catch them, you need to give them to the warehouse at like 5 o'clock in the morning. That way they can go and give them to the businesses. So it's not a typical 9 to 5, but it's agreeable between the parties because that's perhaps actually considered acceptable in that area of business. And so as long as the both sides agree to how things are going to be done, it's okay. It can change, it can vary. And if you have a receipt, you buy anything, you order anything, you usually have a receipt and you can refer to. That way it's just a record keeping mechanism of what was purchased, the price, and whatnot. When we talk about auction, we talk about when things are going up for sale and people are going to bid that price up. And there's actually differences between putting up an item with a reserve and without a reserve. If you've ever used eBay, you should know what I'm talking about. If you've ever watched any type of auction on maybe cars, or there was something the other day on, I don't remember what kind of car it was, but there was a bunch of cars that were being sold at auction on some kind of TV channel. I don't even know what that was. And people were bidding, like they were bidding. If you've watched Storage Wars, right? there's a particular item that's up for bid, and they start the bid at a certain particular price. That's their bottom, and then people bid that up depending on how much they want it. When we talk about an item is being put up for auction without a reserve, it means it's starting at zero. There's no bottom line. But if you start it at a reserve, that means that's the lowest price that the seller is going to take for that particular item. And it's good thing to know. And I usually tell the story. The first time I used eBay and I thought I was going to be an entrepreneur and I thought I was going to be selling all this stuff. My mom has tons of stuff in her house, and just random stuff that she buys randomly that she thinks are all antiques, but they're not always antiques. So I remember, when the whole thing on like eBay came up, and she was like, all right, let's sell some of this stuff online. I was like, all right, Ma, we can do this. I'll help you with it. And I put this thing, it was this metal thing, and if you look up, I still remember this because you learn in life the hard way sometimes. It was S. Kirk and Son, and it was a metal company that was around in I don't remember, I think it was like the 1920s or 1930s. And so she had this little cup thing, and I put it on, and I'm like, oh, I'm going to get hundreds of dollars for this thing. Ma, you're going to be rich with this. And I put it on, and I didn't know about the reserve thing with eBay. It was like my first one. And I put it on for like, $1.99, because I'm like, people are going to be bidding this thing up to no end. It did not go up. As a matter of fact, when the auction ended, it was like $9.99 or something. And then I was like, oh, I don't want to give it to you for $9.99. This thing is worth so much more. And then the person who purchased it, he's like, no, like, you have to sell it to me because, it's not worth that much. It's a milk holder or whatever, but you have to, like, we entered into an agreement. You put this thing up, I made a bid, I paid you for it. I was like, I'll return your money. He's like, no, but like, that's not how it works with eBay. And I was certainly a lot younger, and I was not familiar with eBay and the rules, and I didn't want to be banned from the world of eBay, not realizing I could just make another account or anything like that. But I ended up selling it to him for those $10. I mean, I probably paid more in shipping than anything else, but I didn't want to tell my mom that I did not sell it for hundreds of dollars. So I told her it sold for like $125, and I gave her $125 because I didn't want her to feel bad. But that example has always stuck with me. And that's why I always tell people about auction with reserve and without reserve, so you don't make the same mistakes I do in life. So that is auction with reserve, without reserve. So now, lesson learned. Let me see what else I have to tell you. Zip at you. See, that's why I can't teach with kids here, because they're going to rat me out. I don't even want to talk with him here because, it's never good.
Yep. Yeah.
Okay, so with that being said, there's nothing else I want you to know. Let me see here. Is there anything else on consideration? Okay. That's all I want you to know for chapter 19. See, not really my favorite chapter. Nothing good here. We're going to move on. Does anybody have any questions? Does anybody have any questions about any of this good stuff that I just pretty self-explanatory, pretty simple stuff, right? Common sense. There's only like 3 live people that I'm seeing on the screen right now, and since they're saying no, their word kind of governs. So, whatever they say, that's good by me. All right, we're gonna move on to chapter 20. Chapter 20 is it's performance, place of tender, time of. This is kind of a little more entertaining. I can have a little more fun with this. All right. So again, it's kind of simple stuff, self-explanatory, and especially in today's world with like uh like ordering everything online and whatnot. So when we talk about performance when it comes to sale, it's basically when you do what you're supposed to do, when you carry out the obligations in a contract. What does that mean? You've performed your end of the contract. You're good. This is a write it down moment. I want you to write this down exactly as I say it. The basic obligation of the seller of goods is to transfer and deliver the goods. Actually, I'm going to put this down in your chat. Just make life easier. Hold on. Hold on 1 minute. Okay, so this is something I want you all to know. The basic obligation of the seller of goods is to transfer and deliver the goods. The obligation of the buyer is to pay for the goods. I'm going to say it one more time. So the basic obligation of the seller of the goods is to transfer and deliver. Obligation of the buyer is to pay for those goods, right? Very simple. I'm buying something from you. I have to give you the money. You have to do what? Give me the goods. When you order something on Amazon, what do? You pay. What do? They send. Very easy, very simple. We're all on the same page here. So that is the basic obligation. That's something I want you to know. And now this is now back to listening. Each party should not impair the other's obligation to carry out those duties. So you can't try to prevent the other person from doing what it is that they're supposed to do and then hold them accountable for not doing it, because why? You're trying to not have them do it. When we talk about performance by the seller, right? The seller is the person who's selling this item. You you're delivering the item, right? You're the seller. You have this particular item and you're selling the item. You're giving it. You have to transfer the item. So you basically um transfer it, whether it's through some kind of mail or whatnot. You tell them reasonably that, hey, this item is going to be shipped to you by this period of time and at this date, right? When you order something online, what do you often get? What do you get? Because I'm trying to now kind of make it like about what happens today. When you place an order online, what do you usually get right after that?
Email confirmation,
Email confirmation. What else do you usually get? So now you've placed the order. What else? What other correspondence do you get from them?
tracking info.
That's right, tracking info. So that way you know, right? You know when this item is going to be sent to you. You know when this item is going to be mailed. You usually get the tracking number. So now you know that this item is on this. They're not doing this out of the goodness of their heart. This is because it has to do with the sale of goods, the transfer of property. They're notifying you of the time of tender, the place of tender. The place is it's going to be shipped to your house. That's the place of tender. That's where you're getting that particular item that you ordered. And the time of tender is the rough estimate of when you're expecting to get that delivery. So when we talk about place of tender, time of tender, tender is when you're just getting that transferred item. Okay. So this is something called the perfect tender rule. This is also something I want you to know. So I'm going to explain it, and then you can write down whatever you want. But this is something I want you to know. This is called the perfect tender rule. And the perfect tender rule imposes on the seller to conform the goods exactly what was ordered. And if there's any failure of that, the purchaser has three options. They can reject the whole, they can accept the whole, or they can accept some and reject some. And I'm going to explain what that means to you. If I ordered 100 blue pens from Amazon, all right, I ordered 100 blue pens from Amazon, and Amazon sent me 90 blue pens and 10 red pens. I received those. It's not what I ordered. It is not what I ordered, right? I ordered 100 blue pens. So I can either reject the entire lot, I can accept the entire lot, or I can accept some and reject some. So that's the perfect tender rule. You have those three options: accept all, reject all, or accept some and reject some. Also, when we talk about like time of tender and place of tender, when the contract doesn't specifically state, or the transaction doesn't specifically state where the place of tender is or the time of tender, if it doesn't specifically state it, you have to assume that it's going to be a business location between the normal business hours, 9 to 5. So if you're ordering a lot of, you're having some kind of printing company print, 1,000 postcards of whatever, right? And their website, all their information says that they're open Monday to Friday, 9 to 5. You're not going to go there on a Saturday and try to get your items because clearly like their establishment is not open those hours. You're also not going to go at midnight and expect that they be open, that they're going to give you their stuff. However, if you are going to be DJing and you're dropping off maybe DJ equipment to a club that only operates from 10 p.m. until 3 o'clock in the morning, you might not want to go there at 9 a.m. because they might not be open. That's not their regular business hours. So you have to look at wherever business you're ordering from or transacting with, you have to kind of take a look at their business model, their hours, and then see what the standard of place and time of delivery, what's standard for them. You can kind of take a look at that and see if it's not specified in your agreement somewhere. The next, so that's that. So going back to that perfect tender rule, right? So you know that pens, the 90 pens and the 10 pens. You know just from experience in life, right? So if you got the wrong item from Amazon, what do you normally do, or any other company?
Return it.
You can return. Are you going to return the red? Are you going to return the 90 blue ones that you got? Because you got 90 out of 100.
That seems like more effort than it's worth. Like to
Right.
return, ship it back to Amazon over 10 pens.
Yeah. So what do you normally do? You probably negotiate something. You'd call up the company and say, I received the wrong order, and you try to work something out with them. The seller usually has an obligation to try to remedy the situation. And if the situation is not remedied, then you can ask for a full refund if they're not doing what it is that they're supposed to do. But again, most businesses will try to remedy it. They'll say, listen, keep it. We'll send you out those. You can keep those red pens that you got, those 10 red ones. We'll give you some, the 10 blue ones that you ordered, and they'll try to come up with a way to remedy the situation, because again, they want to keep the business. So that's cure by the seller. As long as they try to cure the mistake within a reasonable period of time, no harm, no harm, no foul. You also have a duty, right? When you get the item, you have a duty to inspect it, right? So let's say you order, and I've dealt with this, and my husband's here, so he's gonna hear. They're hearing all these mistakes that I make. So sometimes, how like if you order like clothes online, right? So let's say you order something, but you don't try it on right away. So you just put it away. You only have like 30 days to return it. So guess what? If you don't try it on, if you don't inspect your item to see whether or not it fits, it conforms to your taste and like, now that the return period has ended, you can't return that item. So you have a reasonable period of time for an inspection of that item. Failure to do that will result in your closet being full of a lot of things that you're not actually wearing or using. So you don't want that to happen. So make sure you inspect. You know what, Christopher, I don't need your commentary. I have your dad enough. Thank you. So what you want to do is you want to inspect the items to make sure that they conform to what you ordered. You can either then reject them outright, you can accept them outright, or again, you can try to, do an exchange with that company and, see if they'll make right. This is also usually the time where I tell this wonderful story. It's things happen in life, and you just don't realize that they're going to play a part in your CSI lectures until it's time. So back in the day when I was in college, I was the president of the student government, and I remember my exec board and we went out to lunch or dinner or something, and so we all ordered our meals. And one of the guy, he's a peculiar guy, so he ordered, it was a chicken marsala. That's the one with the mushrooms, right? So he ordered that. He basically cleaned his plate, right? So then the waiter comes and says, "Oh, was everything, to your liking?" We're all like, "Yeah, yeah." And then this kid who cleaned off his plate starts to complain about the food, the taste, and all this other stuff. You ate the entire thing. What are you going to do? Return it? There's nothing to return. What are you going to do? You want a refund? You ate the entire thing. What do you want? So it just was that. I don't remember a lot of things. I have a really bad memory, but that's one of those like things that kind of stuck in my brain. So again, when we talk about inspection and your item and returning stuff and things like that, you can't, after you've eaten an entire meal, try to reject it. If you've ordered, you know, sponge cakes. I think you did the same thing with like sponge cakes. Like um you ordered a bunch of sponge cakes and let's say you order 100 of them and you've eaten 98 and then you want to complain about the taste. You ate 98 of them. You can't do that. So whatever it is that you get, my husband thinks I'm crazy. I'm not. Whatever it is that you get, you need to inspect it and make sure that it conforms to your expectations. And then if it doesn't, then you can try and return it. And if it does, great, more power to you. That's life. So that, my young people, is acceptance and revocation and stuff. Also, once you accept something, you can't then like try to reject it. It's kind of like no backsies, all right? So you accepted it, you take it. If it conforms, you can't then try to, reject it later. Um, if it's within that window of time, then you're good. Um, okay. Yeah, as long as it's within that window of return, then you're pretty much good to go. And if it's outside that window, then you'll have a problem. Now, there's certainly exceptions to these rules. These are general rules, but just so you can kind of have an idea. Um, okay, obligation of payment. See what kind. Oh, I forgot to give you. You know what? Let me give you a phrase of the day. I don't want to forget that. Jeez, hold on. Hold on, young people. Hold on. I'm gonna give you the phrase of the day. Today is okay. What's this? Is a Wednesday night? Wednesday night. Okay. The phrase of today is this year is looking hopeful and brighter as compared to last year. This year is looking hopeful and brighter as compared to last year. Again, this is the secret phrase for tonight, so you can get credit for attending tonight's lecture. Last time, this year is looking hopeful and brighter as compared to last year. Let me save this.
That's not really a high bar, is it?
That's legit, man. That's just actual.
Yeah.
That's legit. So when you go out, off topic, this time last year was so different. So, things are still not perfect. We still have a ways to go, but at least there's hope of improvement and life. And I will tell you, I value, and I've made a lot of changes in my life actually. Um, focusing on the more important things because of what this past 12 months, has shown us. So I, for one, I'm saying no more. I'm not trying to do every single thing that comes my way, even though I still, take on a lot more than I can chew. But, focusing on family, focusing on friends, focusing on relationships, focusing on that quality of life and just giving back and really enjoying life. When I go out, if I take the kids to the playground, I'm actually trying to play with them or look at the sky or like take the fresh air in as opposed to being on my phone answering emails. So I think for me personally, this, I've come with like a new outlook on life. And I hope most of you also have done that or at least embraced what this new way of living, what happened this past year are. So with that being said, high frequency outings this summer. I don't even, what does that mean? That mean you're going out a lot more? If you're gonna go out, just be careful and have a good time. Enjoy it. Enjoy life. But don't enjoy too much. Don't be like one of those people that says, none of you. What is that expression? Lolo, YOLO. You only live once. Don't do that one because then you're gonna do stupid, crazy things. Enjoy life, but be safe when you're doing it. Be safe. Be cognizant of the people around you. You know, good stuff. So with that, going back to the lecture of CSI. Okay, obligation of payment. Obligation of payment. What does that mean? You have an obligation to pay for the goods. Duh. So when you're ordering something, you have to pay for it. And you're going to pay for it in the terms that are outlined in your contract. If you're going to be paying for something before you get it, you obviously have to pay before you get it. If there's some kind of payment plan, you have to pay the payment plan, make those payments. Obligation of both parties. What does that mean? the contract says what each party has to do. So just do it. When you do that, you've now completed or performed the entities or whatever is said in your contract. So make sure to kind of just perform what you need to perform. Casualty. Okay. So the next couple of things, right? Casualty to identified goods, non-happening of presupposed condition. So sometimes if you ship something and it's destroyed before it gets to the purchaser, what happens? Well, sometimes the contract will lay that out. And if that's the case, then you can kind of just use whatever the contract says. But if the item is lost before it gets to you, well, then usually the seller kind of eats it. But you also have what? When the seller is selling something, what do they usually have? They have insurance, right? They have some kind of way to protect them. So if the item is lost or damage is destroyed, then the insurance kind of covers that up. So neither side is at a loss. If when we talk about the non-happening of a presupposed condition, if you're entering into this contract based on a particular condition happening, and there's an event of some sort that was unforeseen, well, then the seller and the buyer are really excused from performing the duty. Why? Because something that was supposed to happen didn't happen, or vice versa. So the conditions need to be as you had contracted over in order for both parties to perform their end. Um, right to cooperation. Again, you need both sides to cooperate with one another, because again, they're trying to act in good faith. They're trying to both do what they were supposed to do in order to have this relationship move forward. So again, most sides, you don't want to screw the other side. Yeah, you want to have a good deal. Yeah, you want to have whatever it is that you purchased or ordered or whatnot, but you don't want to screw the other side. I mean, I don't want to say it's the last thing unless it is. The last legal concept that I want to go over is anticipatory repudiation. And that's a concept I want you to know because I like it. Anticipatory repudiation is you can back out of a contract or an obligation if you know that the other side is not going to perform their end. So if you know that the other side is not going to pay because of circumstantial reasons or whatever, maybe they said flat out they're not going to pay, so why should you perform? Then you can actually also, it's not really breach of your end of it, it's anticipatory repudiation. You're anticipating that the other side is not going to move forward with their obligations, and so then you also take a step back because you're trying to really mitigate losses for you. So that is that. Um, and then the last thing that we're going to talk about for tonight is Hessler versus Chrysler Lake Chrysler. Did anybody read that and would like to tell us about it?
I could try.
Okay.
Sorry.
It's a
in the
case I
middle of
don't
eating.
test on usually, so you just do the best you can.
Okay. This one was kind of like a weird one for me.
Yeah.
It was a little confusing.
Mhm.
But basically what I got from it was that this new car came out. I forget what it is. I think it was called a Prowler.
Yep.
But the production was kind of uncertain about how
Mhm.
many were being made, where they were being distributed. So the plaintiff tried to purchase from Crystal Lake Chrysler.
Mhm.
He put down a down payment of $5,000, and he was basically told, because they didn't have any on hand, that as soon as one made it there, that it would be delivered as soon as possible.
Mhm.
Then another person came behind that, the plaintiff, a different customer came in and put down a larger down payment and had intended to pay more for the car,
Right.
and was told that he would get the first one delivered to the dealership. Um, this is where it was kind of weird. So something happened where he wasn't going to actually get the vehicle, either because it was going to the other guy, or because he told him that none of those cars were being delivered to the Midwest. But the guy had actually contacted Chrysler, and they had said that dealership was on a list that was to receive those cars in the future. And then the guy didn't want to sell him the car or something because he had gone behind his back and said that it was going to create problems for him. I think the court ended up siding with the plaintiff, though.
That's right. You're absolutely right. So basically, the car dealership guy, he sold the car to, guy number one. Then after that, guy number 2 comes along who was going to offer him more money. And so he bumped guy number 2 up. And because this was such a limited car, guy number 1 ended up finding out that this, the car was going to be delivered when the dealer had lied about it. And so he sued. He's like, I paid for this first. I was timely. We had a contract. We had an agreement. And so, where's my car? Where's my money? So the guy actually ended up suing the first guy, and he won. He ended up winning his claim, and he got compensatory damages like money. And because the car dealer did what car dealers are known for, which is not being so honest, unfortunately, and he sold it to somebody else when he should have when it was already sold to this first guy. So because it was such a hot item, he just wanted to get more money for it. And so sometimes that happens. And so when you have open pricing or these contracts out there, if a seller or whatever, whichever side it is, sometimes they'll they see that the market has more demand or less demand, and they can get money from somebody else even though they've already contracted with somebody else, but the law will side with the original contractor because it's the right thing to do. So good job. That's very good, Jessica. Does anybody have any questions on any of the items we discussed so far this evening? Okay. Don't forget, the next 2 weeks, it's going to be a lecture. I do the talking anyway, so there's not going to be that much of a difference. But the next 2 weeks, you're going to have an email with a pre-recorded lecture. If you have any questions on those material, you can certainly email me, and I will respond when I have a chance. Or we can talk about it the next live class. So if you have any questions, you can wait until we actually have a live class, or you can email them to me. Or as always, we can just set up a phone appointment and I can kind of talk to you if there's any concepts that you're not familiar with. All right.
Professor,
Yes.
can I ask 2 things? What
Sure.
is your email? Because I had an issue with the second test and I could not find it on the syllabus.
In my emails, actually, if you look at the last page of the syllabus, it's irini.bekhit@csi.cuny.edu. But I'll put it in the chat also.
Oh, okay.
So hold on. It's like the CSI email, so I think there's like a directory for that. Here's my court one. Here's my Gmail one.
Okay, thank you. And the other
Welcome.
thing was, can you just quickly go over again how to calculate your grade?
Sure. So, okay. So let's say you got a 80 the first exam, multiply 80 times 0.3. So what does that give you? Let's do that together.
Like 4?
Did somebody say it? Did you give me a number? 0.4?
No, 24.
24, good. Okay. And now you got let's say a 60 on the second exam. You're going to multiply that times 0.3. What does that give you? I'm going to take
18, yeah.
18. Okay. So now that's for 2 exams. Now let's say you've attended all the classes and you're going to get those 10 points for the lectures. So you're going to get 100 for the attendance portion times 10. That's equal, I know this one, that's 10, right? That's my mathematical genius. So now if you add the 24 plus 18 plus 10, so that's how much is that? Oh, 28. I already gave the sentence of the day, buddy. Sorry, I'm not going to repeat
52.
it. And do not put it in the chat. So if anybody was listening, you're going to have to watch the lecture again. I said it like 3 times. So 24, 18, and 10. What was that? What's the answer for that?
52.
52. So 52 constitutes 70% of your grade. So now let's say you study really hard, you get like a 90 on the third exam. What's 90 times 30%?
27.
27. So the 27 plus, what was it, 52?
Yeah.
Okay, 52. What does that equal? 7, 4, 5, 6, 7, 79, right? That's the total. So that 79, then you go back to the syllabus and you go to that section that has the breakdown. I'll put that also in the chat. So here is the numerical grade, copy. And here is, I just go through that chat, like I go whatever number you get, and that's how I calculate your grade. So for this person, since for that we got 79, this person is going to get a C+.
Okay, thank you. I understand.
Welcome. All right. So anybody else have any questions? Okay, so I'm going to stop recording.